Thank you very much for that fabulous introduction. I'm really glad I didn't do it myself, because I couldn't have done myself as much justice as you just had. Even to the extent that you mentioned my two middle initials. Thank you for that. You can call me Simon if you talk to me afterwards. First of all, just to say thank you very much for the invitation. I've really enjoyed the 2 days I've spent with the APA group so far this week. Enjoy Sydney. Should I say it's the best city in the world? Is that something? Yeah, it's the best city in the world. My name's Entwisle. I live in a tiny little village called Entwisle. Bit of personal data exposed there. And yeah, that's the second nicest place in the world. But it hasn't got an opera house, I'm afraid. So thanks very much for inviting me. I listened with incredible interest to that first panel, with interest and with increasing amount of depression, as I realised that they covered a lot of topics that I was going to present here, which is always a little bit daunting for someone who's coming up to present next. But the other thing that made it even worse for me was that the discussion was so esoteric, so high level, I could never hope to match that. I'm an operations person. I'm not a policy person. I've worked in a regulator's office taking action against you lot, enforcement action. I don't trust you. I never will. We call it healthy skepticism at the ICO. It's not our job to trust you, but trust is vital. And it's part of the ICO's mission under the new commissioner, Elizabeth Denham. We still call her new. She's been there a year now, but in the UK, it takes a while to bed in. And we've got a new mission, and it's about improving trust in the way that improving trust from individuals in the way that their data is handled by organisations. So we're keen on improving trust, but we can't afford to be too trusting ourselves. Now, joking aside, if that was a joke, we need to maintain this healthy skepticism, but we're not ridiculous. We do accept that there is a degree of trust between any regulator, including ourselves, and those who we regulate. Right. I'm going to move on to the actual presentation now, shuffle my papers around. I've got this huge iPad here, which is for the next session, but I'll try and do my best to just get these microphones sorted. I was going to talk about, first of all, say a couple of spoiler alerts for you in the presentation. First of all, if you're not fully across what artificial intelligence is and that sort of thing, I just want to explain. I'm not going to try and explain it to you in detail. There are not going to be any robots wheeled onto the stage to show you what the latest innovations are. What I'm aiming to do is to try and explain the implications, as far as we are aware of them, on privacy, on data protection issues, and the work that we've done in the UK to try and explain those for organisations. Now, you may or may not be familiar with the ICO website, but we just relaunched our guidance treatise, I'd say, on big data, artificial intelligence and machine learning. It's a long paper, it's about 200 pages long, lots of reference points in there, but it contains a lot of very useful information, I hope, for you if you want to dig deeper into this subject. But what I'm going to do is just canter through the main sort of talk about the implications of collecting big data, machine learning, and artificial intelligence, a word I struggle to say, and then give you some compliance tools, some of which you'll be familiar with, because they're not necessarily new tools. It's around slightly making adaptations to how you use them in order to fit this new world of big data and artificial intelligence. Well, I say new. Is big data a new thing? Hands up, everybody think it's brand new, or is this something that's been around with us for years? I try to look up the sort of first examples of anyone trying to take a big data set and arrive some sort of general decisions about it. And I found the one, it related to collar sizes. Are you familiar with this? Collar sizes for shirts in a number. Maybe this is just men. Oh, I'm not going to carry on with the male-dominated presentations here. But apparently, at the turn of the century, shirts were bespoke. But they gathered together a lot of data, and they found that if your collar size was X, then the dimensions of the rest of the shirt were likely to be within a certain range. So they used that bit of big data in order to decide the shape of shirts. And that's the same to the present day. Now, that's not exactly the same as driverless cars, is it? But the principle, I think, does continue. So just get the first slide up. It does fall on us to give some sort of definition of big data, AI, and machine learning. And I'm going to give definitions that are sort of relevant to the work that we do, really. Big data is often referred to by an acronym. Have you heard the description, the 3 Vs? Has anybody heard that? Yeah, some of you have heard of it. Well, it's around volume, so it's a lot of data. Velocity, which means it's real-time data very often, data that's been collected quite recently or even is being collected. And variety, bringing together many different sources of data. In traditional UK and perhaps American and other English-speaking nations' traditions, people start to add other words beginning with V to the definition, such as veracity, value, viability, and validity. But basically, as far as we're concerned, it's a lot of data. Perhaps most useful for us to think of it, big data, in terms of data which, due to its characteristics, is difficult to analyse using traditional methods. What's AI? Well, at its core, we see that as essentially a form of data analytics. Exciting, complex, but data analytics all the same. Computer programs behaving in ways we would think intelligent in humans. Modelling aspects of the world and anticipating future events. Learning and responding intelligently to new data. And this is the key. And I'm sure others could give much better, much more comprehensive definitions. But for us, the key here is that artificial intelligence and machine learning, which are the algorithms that go behind this learning from the data, learning from decisions that have been taken, present some of the key challenges for us in the data protection world. Because things aren't the same at the start of the collection of the data as they are as the data gets processed and dealt with. That's something that's a bit different from us. It's not a chunk of data that you can store somewhere, protect. It's data that's being analysed, and it's creating new algorithms. It's creating new information. It might be about individuals, it might not. So those are just a brief attempt at some definition. I'm just going to have to get myself a drink of water here. So what are the data protection implications of those of big data, AI, and machine learning? Well, someone mentioned this morning the concept of fairness, and that I think sort of said that wasn't a concept in the data protection world. Well, it certainly is in the UK. We talk about processing being fair and lawful. We talk about the expectations that people would have of the way that their personal data is dealt with. Oh, sorry. You really are doing your job now. So this is about what would people reasonably expect their data to be used in the ways that it is with big data, with artificial intelligence and with machine learning. How do you know how your data is going to be dealt with? Going to be quite a challenge when the whole point of this is to learn from information, to create new information, and how do people know what's happening? How do people consent in these circumstances? Consent's a big deal. We've talked about it this morning. It's difficult enough now with the complicated privacy notices that you see on websites, but how can you consent to the processing that you don't even know what's going to happen with it in the future? What about legitimate interest? That's a concept that you can process data if you've got a legitimate interest to do so. Do your interests override those, the organization's interests, override those of the people whose data is being analysed? Is the use of AI or machine learning actually necessary in these circumstances? And we've got the data quality principles. This is a big deal because by definition, this is big data. Is this just hoovering up all the data, too much data? There's a concept of you shouldn't collect excessive information. How do you ensure that the data that's being collected isn't excessive? What about retention? I think someone mentioned the idea of, well, it was Virginia, mentioned the idea of data being deleted after a certain length of time. That's a basic data protection principle. You shouldn't keep data for longer than is necessary for the purposes for which it was collected. So people should be deleting the data in due course. But how do you decide how that principle applies when you might say you want to use that data for significantly longer than you would in other circumstances? It's a big challenge and something that we as regulators are going to face in the future. Then you've got the issue of accuracy. Accuracy is fairly straightforward now, but believe me, it also can be extremely complicated. With big data, it gets even more difficult. There's the accuracy of the actual data itself, and then there's the accuracy of the interpretations and the accuracy of the information that comes out of it. So it might be that your facts are correct, but the way the algorithm, and we'll talk more about algorithms, you'll be pleased to know later on in the presentation, it may actually take that accurate data and turn it into something inaccurate. And I think we've been given some examples of that this morning. What are the data protection implications for us regulators if that happens? And we've also got this issue of accountability. Again, something that we've talked about already. But this is a new explicit principle, something that we've been applying in the UK, but I think in many other jurisdictions is this idea that organisations are responsible for how they deal with data protection. It's explicit under the GDPR. When machine learning algorithms are so opaque, is it possible to be transparent about what's happening? How do you know what's going on inside the box that processes the data? How do you know what's happening to your data? We've been given examples already of people being taken by surprise in some quite challenging and ethically difficult circumstances. So how can you hold those algorithms, which is an equation, if you like, to account by explaining what's happening and why? How can you get the companies, the organisations, or yourself to explain to the public what you're doing and why? And in doing that, how can you get this trust from the public that it will be so important, I would suspect, to all your business models? I'm now going to run through a few compliance tools that you can apply when you're working with big data. Now, these aren't particularly innovative. These are tools that I'm sure a lot of you were familiar with. Certainly in the UK, they are familiar tools, and I know from the work that I've seen in Australia, you're probably already familiar with these tools. But it's a package of measures that you can take in order to achieve compliance. So I'm going to run through those, and then I'm going to talk a little bit more about going beyond compliance. And this is where I may mention some points that were already referred to this morning, and perhaps give you my take as someone who's been, however many years it was, in operations, in other words, actually dealing with enforcement issues and complaints, and knows what the public out there think, as opposed to organisations or theorists and policymakers. I think the key thing we want to emphasize is that data protection and big data are not mutually exclusive. This whole idea that big data is potentially significantly beneficial, we buy that. I'm sure no regulator would argue with that point. There are massive advantages to be had from big data. We talked about risk assessments. For me, and for the ICO, we work with risk and opportunity. We like to think we do anyway. And this is the balance here. There is a lot of risk, but there are massive opportunities. And we've seen and heard examples of them all the time. Implications does not mean barriers. We think we see them as opportunities. There's opportunities to encourage creativity and innovation, to ensure data quality, to improve trust with and empower consumers and citizens. So if done properly, this is massive opportunities. So although data protection legislation is always there in the background, the things it requires organisations to do are things that we think you'd actually want to do anyway. It might not be easy sometimes, but it is desirable and beneficial to achieve and go beyond compliance. And this is what I'll talk a little bit about after I've gone through some of these compliance tools. Now, the first thing we talk about at the ICO, and I think in Australia too, is this concept of anonymisation. But that slide's not very good because that's not what you call it here. This is called de-identification. It's the same thing as far as we're concerned, just a slightly different term, so apologies. But what it means is if it's data, not personal data, then you don't need to worry about the data privacy implications of it, because the data protection acts are only required when you're dealing with personal data. There are many uses of big data where the answer will be no. This is general research with insights about a whole population as opposed to at an individual level. So I've got loads of examples of that, and my favorite example is the search for planets that can be inhabited by the human species, if you like. Masses of data being worked with in order to find those planets and hopefully find life on those planets. And I have to tell you that GDPR will apply to those individuals should we discover them. So where it's not possible to identify an individual from the data itself or in combination with other data, then it's not personal data, and it's not personal. If it's not personal data, not covered by the data protection legislation, and that's explicit in the GDPR. They've actually let some data go. It doesn't mean data protection needs to be ignored in those circumstances. And why is that? Well, because the nature of what you're doing here means that data that isn't personal can turn into personal data. We talked about this yesterday. It was a point well made by our colleagues from Singapore that if you're doing analysis and pulling together non-personal information, it is not just theoretically, it's actually it can happen that then becomes data that you can identify an individual from, and it does become personal data. So even though it's anonymized, you should be it's de-identified, you should be keeping an eye out for this possibility that it becomes personal data. So doing it properly is key. Organizations need to carry out and document robust assessments of the risk of re-identification. So we have also heard a lot of talk about, well, no data can be de-identified anymore. Well, at the moment, that's not quite the stance we take. We still believe that it is possible to take reasonable steps and on a risk-based approach to de-identified data. But very challenging and a job that you need to take very seriously. But a big point for us, if it's data that's anonymous, de-identified, then it doesn't. The data protection principles don't apply. The ICO has got an anonymization code, so if you look at that, if you wanted to look at something outside the jurisdiction here, I'm sure there's work on the Australian website. But if you wanted a second view of what's happened outside in the UK, then by all means have a look on our website and look at our anonymization code of practice. Quite a complicated area. So, moving on then to you can't de-identify, it's got personal data in there. Well, the first thing we've got are privacy notices. Now, are there any lawyers in the room? Hands up. Oh, no. Good. Well, I say, oh, no, it's another spoiler alert. At the end of the session yesterday, there was talk of lawyers being replaced by mathematicians because of the nature of assessing how effective an algorithm is. So, get swatting up on maths. That's all I can say to you. Well, if you're a lawyer, you'll know about privacy notices, won't you? If you're a punter, if you're someone who logs onto a website, you'll also know about them. And you'll know that you don't read them. Research would say that very few people, other than probably the people in this room, actually read privacy notices. But they're still an important part because they can give you, as the organization processing the big data, some sort of consent. But they have to be different for big data. There are opportunities to make them more accessible to people. And we saw a fantastic example of a SBS, the broadcaster, with a little video saying how they would deal with people's personal data. And that was one you would watch to the end. It was only 3 minutes long. Other organizations now use, maybe some of you do, use little cartoons. They use films. And they can go so far. They can actually engage people and make people just realize and maybe reassure them about the use of personal data. But that's a bit harder when you're talking about chunking and using big data in ways that creates new information. And in these circumstances, we talk about layered privacy notices, so notices that can be issued to provide an increasing detail at each layer. This reduces the burden of supplying a lot of complex information at once, while still allowing people to access the detailed information about the areas that matter to them. And I know there's a concern that if you tick the box on a privacy notice, you can't really do anything until you've done that. But I think some of the approaches may actually help. There's notices that we call just-in-time notices that can be useful to help spread the provision of information. Then there's graduated consent models. People can give consent or not to different uses of their data throughout the relationship with an organization, rather than to have just a binary choice to the start. And there's also use of standardized icons, which is a way of sort of company written information that may help to highlight how key parts of that information and give people an instant understanding of how their data is being used. So privacy notice is very important. And remembering that if you're using big data, or if you're involved in a project that's seeing changes emerge from the initial planned use of that data, you must consider whether or not those who've already signed up, who have already given their consent, would still want to give their consent. That's very important for us to do. We don't think there's one size that fits all, and you need to consider a combination of tools. And I think in this area, as in the rest of the things that I'm going to talk about, it's very true that this is an emerging area. We don't have the answers any more than you have the answers, any more than we had all the answers this morning. Things will develop. So as your project develops, you need to think about the privacy implications. But as the law develops and as regulatory approach develops, we all need to think about how we're going to do things in the future. So in order to effectively convey a privacy notice information, it's unlikely that this will be achieved by lawyers alone. Instead, beneficial to facilitate cooperation between a compliance department, service, design, user experience, professionals, so that it can be set out in a way that people can understand, and to help ensure that not only is the right information provided, but it's done in a way that people find engaging and intuitive. And this will help people to absorb and understand what will happen with the data. And I think, going back to the trust point, if you understand the privacy notice rather than just click through it, then that helps with the trust side of the trust that people can have in that organization. Another tool that I think you'll probably be familiar with is privacy impact assessments. Now, this is very well developed in Australia already. You've got some excellent tools online, so I'm sure you're all familiar with this. With big data, it can involve complex, unexpected uses of personal data, though. So it takes the intricacies and the issues of privacy impact assessments that makes them even more complicated. And we saw a fantastic slide this morning that more comprehensive than I could ever do on the platform here, sets out the sort of factors that you ought to be thinking about when you're doing your privacy impact assessment. Very challenging because it's a developing world. I was really impressed by that. I've seen some of it before, but the work continues in giving you the advice, the guidance, and the tools to make these assessments that really work. So one of the early steps in a privacy impact assessment is to describe the information flows. That is the collection, the storage, the usage, the deletion of the personal data. All the things that relate to the personal data implications that I mentioned at the beginning. But when you're using big data, it might be a little difficult to describe at the start what the purpose is of the use. Because there may be no explicit hypothesis that you're trying to prove. In fact, that's one of the big advantages and the big benefits of big data, is it throws up answers that you didn't know the questions to, if that doesn't sound too Hitchhiker's Guide to the Galaxy for you. So in those circumstances, it's quite difficult to set up at the outset in the privacy, when you're doing your privacy impact assessment, works with as much clarity as I think you'd like to do. So we would encourage organisations to think very carefully about any sense of purpose, even if you haven't got as clear a purpose as you might have for the sort of processing that you do now. So when you've got that sense of purpose, we'd say that you're better placed to identify tasks, to identify risks, mitigate and integrate the solutions into the project. Your opportunity there is essentially the purpose. So we're not ignoring that fact, but to get to that opportunity, to get to that purpose, there are going to be risks, and you're going to need to mitigate them. While this is not always an easy process, breaking it down into simple question and answer, it can help with implementation measures. So how are we being transparent and fair about the particular profiling exercise? When will we inform customers? We'll inform them at the start. At what points are we going to inform them of changes down the line? Will we inform existing customers through business as usual comms? Can people control their involvement by an opt-out that they can exercise at any stage? And then around the way in which you would deliver your privacy notice. So build on the tools that you've already got, but accept that with dealing with big data, with analyzing big data, you're likely to throw up changes. We've got some examples in the UK of where we've taken enforcement action where it's involved big data. And a very recent one involved Google DeepMind analysing medical health information around kidney infections, working with a hospital in the NHS. It involved a trial which used a lot of personal data. Now, what did you want to do there? You wanted to stop people developing problems through kidney infections. Now, who's going to argue with that? It's a fantastic aim. Can that aim be achieved and still protect people's personal privacy? Of course it can. Of course it can. But does that involve ongoing consideration of the risks and the impact on people as you develop your trials and as you move into the real world? Well, yes, it does too. And in this case, the enforcement action that we took was to get an undertaking from the organisation to take some slightly different steps than they'd been taking in the past, because we didn't feel they'd been quite alive enough to the needs and requirements of the patients. And they accepted that they're learning too, and that they had sort of focused on what the doctors were telling them, what the medical profession were telling them, and perhaps concentrated on that at the expense of the data of the actual patients themselves. So a real example there of how continuing to look at what you're doing. I don't know whether this is actually described as a privacy impact assessment, but it's around continuing to consider the risks as the project develops. Again, it's hard for me to disentangle these particular compliance tools because they're so interlinked. And again, as I think it was Peter's slide show this morning, it's one big set of questions you need to ask yourself. I think that's quite a simple way of putting it. Privacy by design, it's about making sure that data protection and privacy issues are thought about as early as possible. And that goes back to that example that I just gave you. They were thought about early, but they didn't continue to think about them place enough emphasis on them as the project developed. So appropriate measures can be identified at the outset, implemented at this point, and as the project develops. It helps ensure that such issues aren't just forgotten about, or worse, ignored. It's particularly important for complex processing operations such as AI and machine learning, where addressing privacy risks will become more difficult as a project moves forward. So this idea of privacy by design is often associated with techniques to anonymize or pseudonymize personal data. So de-identification. Sorry, I've got some notes here and it keeps saying anonymize. It's really important that you consider this issue of de-identification as the project moves along. It may be that you can't de-identify at the start, but it may be later on, as an offshoot of the project emerges, that can be de-identified. And that's something that we should be thinking about during the course of the work. Data minimization is also important. Going back to the point I talked about before, it's not about just hoovering up everything and just keeping it on file forever, just in case. It's about keeping data relevant and minimizing it. If you don't need it, we can get rid of it. And data segregation measures to ensure certain data sets can't be used for incompatible purposes. So these are around the privacy by design approach. This concept is actually now included in the GDPR. We're going to talk about that in a minute. Referred to as data protection by design and default. And I think it's one of the many good things in the GDPR, an example of the greater emphasis it places on accountability. It doesn't apply in every case, but when you're talking about big data, that's likely to be a situation where the GDPR would expect this privacy by design approach to be adopted. No longer an afterthought, no longer something to tack on at the end. You should always be thinking about it at the beginning and throughout the process. Now I'm going to move on to some probably say a little less than I might have about some of the beyond compliance issues. This is where we discussed before. I've not been moving my slides on very well here. Ethical approaches. Now, I don't think there's a lot that I can add to the sort of definitions of ethics. They were very well explored this morning. But as far as we're concerned at the ICO, an ethical approach is more important than ever in big data world in order to support and go beyond compliance with the underlying legal requirements. Now, I know for organizations who are doing work in this area, it's often an issue of compliance is enough. We don't want to go beyond compliance because it'll cost us more, it gets more complicated, and really that's not what we're about. We talked this morning and we did get onto the subject of we're here to make a profit. But I think we would argue that going beyond compliance in this particular area and looking at ethical approaches is more important than ever, because we simply don't know what future compliance will look like, for one thing, and also because better compliance means greater trust. We did a survey, and I know that's a similar survey has been carried out in Australia, and we found that 40% of individuals in the UK had not used a service because they didn't trust them. And 35% of people have not used a service because they asked for too much information up front. They simply didn't use the service. So you've got to bear that in mind when trying to get it right. So this goes beyond best practice in our view and goes into your business model for your product or service. It could be a simple set of ethical principles or ground rules, or it could be, if you're a big enough company with enough, if this is relevant enough, you could have data boards as we had discussed this morning. But for a smaller company, smaller organization, this can be done without the need to implement cumbersome processes. You need to focus on the values of fairness and transparency, and really useful for employees to use as a guide when developing new projects. We've all got our own sense of fairness, and we've got a couple of tests that are well known that you could use. There's a sunshine test, where would it strengthen or threaten consumer relationships if the details of what we were doing were made public? Answer, yes. Well, is that how we should be doing it? And then my favorite, the granny test. Would I be comfortable if another organization was using one of my grandparents' data in this way? Never mind your own. These are just simple tests that you can apply without needing to be an expert in ethics or to have a board of ethics. But having a board of ethics, internal boards can make assessments on difficult issues in big data projects, such as when they try and balance an organization's legitimate interests against people's own privacy rights. So we talked a lot about that this morning. I probably won't talk any more about it, except to refer to another example, because I think I said I'm in operations. So I've dealt with some enforcement cases, and a big case we dealt with last year and this year involved charities in the UK. It probably wouldn't have made the news over here, but we found some practices in our charities in the way they collected data, perhaps big data, but certainly a lot of data, and used it in a way we didn't think that their donors would find complied with data protection. What they did was a thing called wealth screening. Has anybody heard of wealth screening? Okay, wealth screening is when a charity gets some details off you, and then they start looking beyond that to find out how much you earn, how much money you've got saved, how much money, what other charities you donate to. They ask you permission to contact other charities and to contact you again, but they don't tell you what they're doing here. And what they do then is they put you in a little high strata. Perhaps all of us in this room would be in that strata of high net worth individuals, perhaps not. But they would then target you with requests for further charitable donations. Now, I don't know what your gut feeling is. If you didn't know about that and you knew that had happened about you, would you be bothered? Anybody be bothered? We're all happy with it? Yeah. Well, the charities said no one cares about that. No one's bothered about that. They expect that to happen. It's all good stuff. Well, we didn't agree, and we had to take regulatory action against a number of charities, because that's how they'd used the data in order to put this profile of you, this picture of you that you totally weren't aware of. Is that ethical? I don't know whether anyone, I'm not expecting an answer, but it doesn't seem particularly ethical to me or to my grandparents, if any of them were alive, I'm sure. So we took this action, and the charities absolutely hated it. They felt that this was perfectly normal, this was something we could do, and everybody accepted it. So I wonder, charities you would expect to be ethical. I'll just leave that one out there. Anyway, they kicked, they screamed, and eventually they changed their practices. Every time this was on the news, everybody said the same thing. They do what? And we were very pleased with the outcome there. Okay, going back to some final compliance tools that I'll whiz through. One of those is big data standards. So we've got various best practice standards that are not exactly specific to big data, but could help you if you like standards. So there's an ISO standard that you can use for international data standards. So the ISO 27001 about data security can help. Some organizations are more into standards than others. This gets you back potentially into box ticking, which in itself isn't enough, but it might be something that you'd want to consider. In the UK, we've got other national standards boards that feed into this area. As far as I'm aware, there is no set international standard yet. There may be in the future. How useful that will be remains to be seen. The other area that we talked about yesterday when we discussed this was algorithmic transparency, which essentially means, at the beginning I talked about, do you know what the processing is doing? How is it working out the answers to the questions? So it takes the data, it comes up with a proposition. How does it do that? How does it work out that actually, if I target my advertising in this region, I'm more likely to get people to reply? How does it do that? What factors does it take into consideration? And there are examples, and I think a couple were quoted this morning, where the factors weren't all the factors that were relevant. So the solution they were coming up with was not necessarily accurate. There's no consensus on algorithmic transparency yet, but there are some approaches emerging, and there may be others who are better placed to discuss this than me. But it's a very tricky area for regulators. Because if you're talking about processing being fair and being accurate, it may involve us, and this is where the mathematicians come in, actually looking at the algorithms that are being used in order to reach those conclusions. Algorithmic auditing can help make algorithmic decision-making more transparent. Certain auditing techniques have been found to be successful at identifying the discrete factors that influence algorithmic decisions. But this isn't easy. People don't want to give out their algorithms. And algorithms are constantly changing. I think this is one of the points that was made very clearly yesterday and is something that affects the whole area. This is not a static area. Things change and the algorithms themselves change regularly. But it can help organizations to determine whether those factors mean that the decision would be discriminatory or biased or would therefore fall foul of the accuracy and principles of data protection. This might be too technically difficult or resource intensive for some organizations, but there are third parties stepping into this space in order to provide those types of services. One of the things that we have seen that helps people, again going back to the trust issue, is a sort of visual or an interactive interface that helps explain what the algorithm has done. Because let's face it, none of us are going to understand it just by looking at the thing itself. I probably don't even know what it looks like. So we've seen examples of graphs and charts that can display the factors taken into account by the algorithm, and adjustable sliders can allow people to change the weight they might give to certain factors and see what the answers are. But again, very much as far as we're concerned, in its early stages, and as regulators go, very early stages for us to decide how are we going to look at this and how are we going to factor this into our regulatory oversight of this big data artificial intelligence area. There's another more simplified approach for certain types of algorithmic decisions, which could be to allow people to just check and correct their outputs. I don't want to fall in the trap that often happens when people at conferences like this are forgetting about the individual and thinking about the organisations completely. It's really important that if there is a way that people can check their own information, that they're allowed to do it. The openness is great, and they can correct it, and they can make sure they then will feel far more comfortable about what's happening and happier with the outcome. And again, trust you more. And by trusting you more, that's a big win for you as an organisation. So finally, just to sum up what we say in our very long, comprehensive paper, first of all, try and use appropriate techniques to de-identify the data if it's personal data in the first place. Be transparent about the use of personal data by using a combination of approaches to provide meaningful privacy notices to people, to embed a privacy impact assessment framework into the big data project, and to adopt this privacy by design approach in the development and application of the big data analytics. And then fifthly, develop ethical principles to reinforce key data protection principles. And finally, developing area, implement innovative techniques to create auditable machine learning algorithms to help check for bias and discrimination and to help understand the rationale of automated decisions. But as I said before, it's not just about compliance. While these things will help to get you there and beyond, you'll also be gaining trust, improving data quality and fostering innovation. All things that we think are ideal ingredients for a successful big data project. Thank you very much.